be an independent call, Mr.
But
Naidu.
could my lords come to the,
What weight with the court?
Millets,
That a
could,
non-existent contract, whether it is a restraint to trade, has been decided. How can it be decided whether
could my lords come to the
whether the
clauses, Millets?
software that you were using for the drone surveillance
Yes, Millet.
was something which was offered to them? You have also said, so on that principle, we said that please produce the contract
That's all.
and let the
Millets,
contract be assessed.
may
independently
I answer that?
taken.
May I answer that, Millets?
We
As far as the nature of contract,
understand what you are saying. Let the issues be kept open to be decided.
precisely,
upon
Millets, that's my
production of the
endeavor.
contract.
Because, Millets, they have to be adjudicated after trial and other things, even by the Honorable Tribunal. Now, that cannot be short-circuited by way of observations which are sweeping. So once it's been remanded, it should have been a clean slate. And more in a contractual sphere, a plausible interpretation was being given in my humble submission, a purposive interpretation being given. Technologies, Millets, I may possess 10 technologies I have offered, and you have chosen one. And when I've written whether you would like to have the next one, I've never ordered that one.
That perhaps finding ought to have been tentative. Whether the order offered will include all forms of technology which were discussed or kept in abeyance.
Or else which has been selected.
The restraint in trade should be narrowly viewed in respect of technology. use.
Precisely.
That we keep it open.
That needs to be,
The
that
only
needs to be
issue-
kept open, Millets.
Well,
That
the
needs to be
only-
kept open. That's all my endeavor.
The way non-disclosure is.
Millets, my lords may can appreciate.
They,
Millets,
they say, I
Millets,
on a contract,
I
not
own
disclose the contract.
Please, please, let me complete. I own the technology. I entered into a JV with an Indian firm. And Millets, I have given ABC technology. We have chosen technology A for India. The remaining one, the negotiations were even before that one. So that's why, as far as Bhutan is concerned, we have given a different technology. And there's no dispute that these two are different. To be divulged, had there been a dispute and they have been alleging that I have given the same technology, no. We're on the same page with regard to the technology. It is different. Now, Millets, whether offered, the whole issue hinges on this issue. What's meant by offered? The tribunal has held in its wisdom, offered means offered and acted upon. Otherwise, Millets, everything gets blocked just because they've been on the display. And Millets, that's the matter anyway to be decided by the tribunal. In 17, it cannot be decided and indicate you pass an award in terms of my directions. I think it's sweeping. That's my humble submission. Kindly keep it open. Let the tribunal take a call on it.
You were saying, you come back to the same thing. So far as the disclosure directions
Absolutely.
are concerned,
Yes.
we do not wish to interfere. We feel
Yes,
we
Millets,
are-
disclosure,
we are
yes.
Fair and square.
Yes.
You are
That's
asking
the
of a
only point.
Millets,
non-confidentiality.
disclosure. May I submit, Millets? Disclosure, your lordships may hold against me. I will divulge. I will divulge.
As the judges observe, there are numerous techniques evolved by courts to have a confidentiality committee and they will examine and all.
Millets, I cannot have a quarrel on that one. Kindly hold it against me. I will divulge everything. As to what is meant by offer, as to what's meant by offer, kindly leave it open for the tribunal to interpret.
Just one.
It cannot, then nothing
Sir,
remains to be decided if offer is to be interpreted.
So far as the offer is concerned, the court found, based on their admission before the court, to say that we offered. That technology, as a matter of fact, was taken for GIS purposes, was given.
Mr. Singh,
Yes.
there has been certain final adjudication on interpretation of terms.
Yes.
One interpretation is offer has to be given its wide etymological meaning.
Right.
Of anything which is on the rack,
Yes.
whether you have chosen it or not.
Yes.
That actually gives, it's a normal meaning.
Yes.
But when you see it against a restraint clause,
Yes.
will it deserve a more restricted meaning or not? If we hold that the judge in 37
Yes.
is final, then the
No, no, today the
application comes to us.
issue is
Kindly see the reason
issue
assigned
is
by the
only
tribunal.
that
That's
they
at
can't
718.
get away with not disclosing the contract. That's one.
I disclose.
That's all.
I'm
All
saying
other
I am
issues are-
disclosing.
The entire award is going to come, and that's subject
Millets,
to
I am
34 data
disclosing.
points.
Leave the rest of the conditions intact.
From
Millets, that's all. Let it be confined to that one, Millets. I'm willing to disclose.
offer is today, they are not saying that the offer is they're deciding. They're saying the offer clause will be in final arbitration will be taken. That's what they're saying. Yeah. Let him know. This is to be taken the time.
I'm willing to discuss.
Yes, yes,
So-
that's the important part.
Kindly leave it to the rest to.
Yes.
To ensure that there is no ambiguity in understanding the impugned order of the High Court, format is clarified that directions contained in paragraph from I to K
Will be implemented.
will
Does not require interference.
Huh.
However,
be interference by this court.
however, observations
However-
in A to H are not binding and will not for the purpose of this 37 will not affect.
Disclosure, no issue.
Absolute.
Disclosure, no issue.
Yes.
Barring disclosure, kindly leave it open for the tribunal based on the evidence.
Disclosure finding was wrong.
So we'll disclose. We'll disclose.
Yeah. With this clarification, this clarification.
Grateful minutes, deeply obliged.
Just,
They're still there.
well, my lords are making it clear, just for my understanding, my lords are making clear that my lords are not interfering, except that the K is the subject to the final adjudication by the tribunal. That's all.
Minutes, my lords have
Yes,
said,
because it
minute
should not happen,
disclosure
they
should
come
be
back
made.
Saying, we are saying that the findings from A to H
Yes,
are for the purpose of disposal of section 37 appeal.
yes,
And when the decision is taken as per clause K,
Yes.
it should be done independently and in
in
accordance.
terms of the contract.
Deeply.
Yes. Yes. So,
Minutes, the name of the Bhutan officials may not be required. The whole contract where,
no, no, it is. There is
Name
a,
of this will
it
open
turns
the
on,
payroll
everything turns
to
on
get
that.
a letter.
so be,
Yes.
Uh,
They interplay
Name,
between.
what Bhutan, what is their confidentiality?
so be it, minutes. It's
And
been
it
to
can't
some
be
other
because
nation, some other
confidentiality is always
contract.
subject to
But
certain
minutes
rules.
where,
It's
you know,
all
it should
required
be-
to have to disclose the court.
so be it.
It may not be disclosed to the party, but the
Absolutely.
judge
To the
prefers-
court.
How can
To
they
the-
tell a-
Minutes to the,
You get a comfortable official from Bhutan,
No,
who writes
minutes.
letter in
They
your
can't.
favor.
to the
and
court we are willing,
able
to the court
tell
we are
you
willing.
And well,
Minutes, to the court we are willing.
which contract there is a blanket,
There is, even the tribunal has said, there's no such blanket one. You have not established your case. That's the case. Minutes will disclose to the tribunal. Great.
well, my lords have said up to J, it is, it's up to I, Malats, because I is the main disclosure clause. Just, yes.
A to H, you're not.
Yes, I, Malats, because that's the one, the final finding on disclosure. Grateful.
Well, it's, just take the file of 84 minutes. There is a direct order of your lordships, tagging it. Kindly hand this over. 3 copies. Well, let's kindly take the file of 84. I've given a chart. It's identical to that. Just kindly hand this over. It's identical to a matter pending with issues common. This item 84, which 81 and 84 go together. For 84, it should be tagged. See the chart below, Manoj. See the bottom of page 1. These are the identity of issues, same issues. I made a chart of issues, but I told you we'll create some problems. Why is para file now? This is 2015. We signed IA.
Different SLP, different one. And it's a different one. It's a different.
Told you. पहले मैंने बताया था आपसे.
Dr. Singhvi, those matters were of 2022.
I beg your pardon?
Those matters which you require praying for tagging is of 2022 cognizances.
In fact, 2015.
15 and 22.
Yes.
Now,
Issues of
here
law.
is a cognizance in 25, 26, post sanction being granted.
with the issues of law being identical. I made a chart. Kindly, Malas, see. Your Lordship saw the issues, said substantial issues at page 59, the order, and then said stay. Three things, Malas.
Substantial issue was more with regard to sanction.
No, Malas. Kindly see the issue. So therefore, give me a minute. Just see the issues first. Just see the issues. Well, it would be, first see the chart, the first page. This first page of this note, Malas. Just Chief Justice has it. Justice Mona has it.
Yes, we got the
At
note.
the bottom, Malas. Prosecution arises from coal block allocation. Prosecution invokes same sections. Now turn the page. In both matters, the challenge is against cognizance and taking of summons, issuing of summons. Whether fundamental requirement of mens rea in any criminal offence can be ignored by invoking 13(1)(d) is a very important. And your Lordship says at page 59, it's substantial issue of law. Then whether cognizance under 409 and 420 and 13(1)(c) and D can be sustained in the absence of prima facie material disclosing entrustment, dishonest misappropriation, deception. Then whether criminal conspiracy and 120 can be prima facie inferred merely from participation in the official administrative screening, and whether it can be sustained only on the basis of competent public authorities' decisions. Now, turn to page 59 of the file. 84. Page 59, in my item 84, your Lordship passed an order on these issues. Your Lordship passed an order on these issues. Item 84, page 59.
Dr. Singhvi, this is when you see issue number 6
Yes,
and the petitioner in 57 or 59
yes,
and the petitioner before us,
yes.
the main distinction comes up.
Miles, on the issue of law, there will not be. There will be on co-accused. There may be on co-accused.
This is what we
Well, it
here
requires to be
before us-
tagged, well,
before us
considered.
on behalf of a beneficiary project proponent.
I am
Before us
Yes.
is one of the persons who at that point of time was in charge of the ministry.
No.
That respect,
two-
whether the
84
participation
is the
one
beneficiary.
Conspiracy is a very relevant question.
Therefore, Miles, give me a minute. Now come to 59 first, then I'll answer my laws. Come to page 59 of item 84.
A
Page 59 of item
project
84.
proponent cannot take advantage of public servant coverage.
the public servant. Same.
So
Since
public
certain-
servants cannot be from the chairman to the chaprasi.
No, but kindly just.
There must be a more equity in the investigation to delineate the conspiracy.
Miles, there
But
were
the
private
fact that
parties.
there was an illegal allocation is not denied.
So, Miles, let me ask you. First, let me answer page 59 of this file, 84. And then I will answer the private party point in a minute. Delay condoned. Let's not order the third para. Since certain important substantial questions of law, as well as the constitutional validity, that also I've raised, of 1D arises. In the instant, we are of the view that these matters require examination. Leave granted. Leave granted. Now, since there were private parties there also. There were private parties there also. He's opposite. See, I told you he's opposite.
So make it the private parties. One only umbrella. See the private parties. See the private parties. And they don't hire and Bhattacharya. Except
And the-
yes, simple.
Now turn to What?
Any other petition pending?
1 minute.
Yes, my lord.
Yeah,
My petition.
item 81 is pending.
Pending, my lord.
Pending.
I am the co-secretary in both the matters.
Now, let's
And my it has been stayed 81.
Notice has been issued.
Notice to
Stay.
same matter.
stay. Kindly see the next para, Manas.
Mine is
No, they are
Next
asking
para.
whether anything is pending here.
Yes,
Yes,
here,
yes,
2015.
First shows that
That's
order.
yes.
That is
So
not
this is the order, Manas. Kindly go further.
Missing order.
It
First,
is
allow me, please.
Oh, it's statutory.
Yes, I'm asking for tagging in the same order of stay. And I'll show the private parties in a minute. Manas, the
Okay.
first part is constitutional validity.
So that is
But since-
5079.
That order I'm reading is in Malas item, is in 1/4 of 2015.
No.
Your Lordship has got it, Malas, page 57
So what
at
ones?
59.
What you ask? Old ones.
My lord has got 57 at 59, Malas. Malas. This किसका फाइल है?
Sir, ये हमारा है, item
ये है नहीं
84.
Two sentences clear. 59 is an order of similar issues, of stay, and all of them had private parties. Justice Bagchi's query, Hindal,
Kumar
Kumar Mallam Birla, Devnaran Bhattacharya, same Mr. Parekh, Nagendra Kumar Sahu, all private parties in that case also. So there will be no difference. Your Lordship should pass the same order. Mallam, that's what I'm saying.
We were only inquiring into, because if there was suppose single matter of Dr. Manmohan Singh.
No, no.
Then
No, he has died, but
Structure.
Mr. Parekh's matter is there.
That is what we are inquiring.
My client is Manos there also.
Yes,
Yes,
yes.
Whether there is a live matter.
Live matter, live matter. That's right. So Lordship, pass the same order, all that I'm saying. Kindly pass page 59 order.
issue notice.
Yes.
I agree with you. CRIMP number 5056.
Good, my lords. Excuse me, my lords.
Stroke 2015 and other connected matters.
My lords, excuse me, I'm sorry to interrupt.
All right, all. And other connecting matters. Meanwhile, there shall be added in terms of the impugned order. First June 2026, passed by special judge in bracket call block cases, bracket close -02.
Yes, that is same order.
Rouse Avenue District Courts, New Delhi. Passed in RC number 321 2014E0018, CBI case number 64/2025. Consequently, further proceedings shall remain stayed till further.
My lords, are granting leave, man.
81 out.
Tag me.
List all the cases for final hearing on so day.
Oblige your lordships.
Get the investigation transferred to any other.
किसको करा दो किसको करा क्राइम ब्रांच ठीक है या सीबीआई
Keep it.
Lord, item 85 in great respect, Lord, is worse than what your lordship dealt with yesterday, which is that Patna matter. Somebody is hit so hard to kill him and he suffers an injury where there are 8 stitches on his head. 8 stitches on his head. And then they say it's a simple injury, number one. Number two, please see 109. Even without injury, Lord, 109 gets attracted. Without injury, 10 years. With injury, even simple injury, life imprisonment. Just have a look at section 109, Lord.
Just see the photographs. May I say something?
Just see the photograph, Lord, first.
Call for the special commission.
Just see page, no, please, but only let me just say what I have to say.
If my lords think that I have nothing to say, it's a different matter. I call for the special commissioner and the DCP West before they
No,
file.
police is acting very strange, Lord. Yesterday, they were forcing them to get into a settlement.
What London attorney
I don't know. So I told them, look, if your medico-legal report given by a private hospital would not inspire confidence, please take this person to a government hospital, get him examined all over again, and change your charges if that is what need to be done. They are going to do that today.
No, no, my lord. We don't want.
Let it be done today. If there is a medical legal report in the basis where they have acted, which says simple injury, it could be wrong. A private hospital would commit a wrong. So why should you go by a private hospital's opinion? I said, please
There is
take him
no
to a government
question of- we are not
hospital,
questioning-
have a clear examination and change the charges.
But when you look at an FIR, a
They,
particular.
I didn't get any impression. I didn't want to get into other
Just see
factors.
page
which-
13, my lord. Just see.
Talk of.
I suppose what I've done is the best interest of the person.
No, you have not. I'm sorry.
We are-
As attorney, we expected more from you.
Mr.
Just see, my lord.
It's very,
No, my lord, it's something very
no,
serious.
Not a question.
Just see page 13, my lord. Just see the injury, my lord, at page 13.
Mr. Singh, we have
Page-
followed
page
your
13.
submission.
That's true. Therefore,
Shows that there is a sharp-edged weapon.
no,
That has-
his head was dashed against the
Scandal.
gate. So therefore, the medical legal opinion is important for us. The local hospital said it is simple. I said, I told the police, I would not like to go by that. Please take him to a government hospital, get him examined all over again, so that we know what exactly the medical condition.
This is what.
Not by impressions we go.
Attorney, this is something which is a question of law, which requires to be addressed by you. When you see an injury on the face, as you rightly say, until and unless we have the expert opinion, it is not possible to have a very forensic understanding
No,
whether it is.
Your lordship is absolutely right.
Or not.
We have,
What happens is, an injury on the head does not qualify within the 7 categories or 8 categories of grievous hurt, out, simple hurt. When you look at attempt to murder, the perspective is different.
I am not,
Intention becomes important.
I understand
And the
that.
action
I-
is not that important.
I absolutely,
When
no
in
disagreement on that question.
situations, what courts have done and what courts persuade, because FIR is essentially an executive premise, courts persuade police agencies to put the case at its highest.
No difficulty at all. The police will do it.
Case at
They will do
its
that. No
highest.
difficulty at all.
Then you
But the problem,
parse through materials and you file a police report under 320.
I only went to this extent.
Details were not taken.
One.
But why?
Let's not make an issue where something is better, it can be done without a difficulty.
Attorney or Mr. Singh.
Nothing, my lord, nothing.
Let's
nothing.
look at it
Not
very
about
objectively.
only the injury, it was also about the concern why no action was
are
actually
the
initiated
accused
immediately also.
I didn't want to get into some background which I think, I don't want to say all that.
RWA president. And the status,
Don't
just
worry.
again, the status report is shocking, Lord. What the police is doing, forcing them to enter a compromise. taking-
No, I stopped them from doing all that.
The matter
Please
was
don't say that.
settled. Just see what the status report is saying. When the second complaint is made to that they are threatening,
Who are the accused persons?
accused is the RWA president.
There are now, the story becomes,
Same colony.
let us, I don't go by the status report.
And 109,
RWA president is being protected by the police deliberately.
let the investigation be done by crime branch, Lord. It should not be done by regular police, by the local police.
Investigation.
The local.
I mean, I'm not taking any stand here. Please be very clear.
Let it, just see, Lord.
Just one second.
Page
This person
30.
is my instructing advocate in item 5, which your lordship. He regularly appeared before your lordships.
No, he's a-
We don't,
He's
He's been here for 20 years. It's all
we
going.
don't need.
Today,
Page,
but
page
I
13,
spoke
just
to
have
him
to get the
personally, my
photograph.
lords.
And
Lords,
Lord,
personally, I spoke
one
to him.
Lord in law, one point in law. 109 does not require a hurt. 109, my lord is aware, Lord. 109, first part is without hurt. 109, second part is life imprisonment if there is a simple hurt also.
Fire a gunshot. into
So if you
the-
say
why-
this 109 is not attracted in this case, Lord, then I don't understand, Lord. So let the investigation be transferred to crime branch,
That's
Lord.
why
That
I
is the
told
first step,
them,
because local
please
police is out
don't
of the
go
way.
by the status
They are
report. I told them
pressurizing.
not to go by the status report.
please-
They will
please-
reframe the
Please
charges, but
transfer
more
to
important.
Crime branch
Mr. Attorney,
and let the FIR be immediately corrected.
submission made,
Yeah.
and also an injury is on a vital part of the body.
Vital part.
So let us,
He could have died.
sir,
I
and
mean-
its stitch on the leg will not attract.
Absolutely. On the
Attempt
head.
murder. So on a vital part of the body, investigation should presuppose the maximum and then go down.
Absolutely no disagreement.
Absolutely.
Go down. So that you.
It will be done.
That is
Right.
the sensitivity to
I
victimology.
entirely agree with you.
Victimology sensitivity prompts the fact-finding agency, that's the investigating officer,
And-
to give the widest berth and then put it under the forensic
That's
lens.
right.
Absolutely.
And you may come
absolutely.
out
I mean,
as
I-
no offense also.
Absolutely.
I can't-
No difficulty
It
with
may
it.
be an accident that
I'm
he
not
slipped and
here,
fell.
I'm not here to take any contrary. view.
Exactly, and we
Certainly
know
not.
that.
That's
So
why I
let the
told them
FIR
to
be
take,
corrected.
don't go by the status report.
We have
Alter your
understood.
charges, take him to a government hospital, get a better
No,
medical
government
report and give a
hospital is-
better report to the court.
The FIR should be amended at the.
He must be taken to a
Let
government hospital.
crime branch investigate. Bro.
Don't say anything no to us.
Just see the FIR, plain reading of the FIR.
We are not,
Why you are not arresting them?
Why should they arrest them?
Because
Why should they arrest them?
1 millimeter deep, you
So next time when you
He would have died.
next time when you come with an application for anticipatory bail, we will ensure arrest of every accused named in the FIR.
They have already been released.
What
on
are you
bail.
saying? You are our
No, no,
officers.
no, no.
Preserve liberty.
Mr. Mishra, one second.
On bail.
He's been released on police bail.
Altercation and
Not-
getting into a fight in this country.
Investigation.
Allow them to actually take proper action, give them some space, and I think attorney is making a,
and whatever.
No, let it go firstly to crime branch because local police is wanting to pressurize the family into settling this matter. So let it go to crime branch. Local police is calling the. होगी शायद है.
Two head constable has been deputed for his security 24/7. Two head constable has been deputed 24/7 for the security.
Why did they enter his house and then they said वो photograph एक बार पेज 13 जरूर दिखा दो.
देख चुके हैं भाई.
इसी पे है. This person is there. कहाँ है?
Right now, don't call anybody inside.
On behalf of the investigating agency, the report has also been produced. Taking into consideration the nature of injury and the vital part of the body where it has been inflicted, where it is inflicted. Now it seems to us that crime of offense like attempt to murder ought to have been incorporated in the FIR, subject to the final outcome of the investigation. Will consequently direct, now what is the corresponding of 307?
109. 109.
Trespass, 452.
Including under section 9 of the BNS.
109. 109.
Ought to have under section 109 and 118 of the BNS 2024.
And
Ought
then
to have been also under section, also under this one.
and transfer to crime branch.
Next paragraph. Since there are allegations like pressurizing the petitioner to amicably settle the dispute, attributed to the local police, in the particular fact and circumstances of the case, we direct the Commissioner of Police Delhi to transfer the investigation to the crime branch.
Deeply, very deeply. And then protection to continue.
To the family.
It's continuing.
प्रोटेक्शन वाला Contempt of Nyaya
452 का corresponding.
That is made of when you trespass for committing an offense. Triple three.
Till the investigation is complete. Till the investigation is complete. With due directions, especially the.
Writ petition. Lord, one more section will apply 333, which is post trespass for the purpose of,
109 and 118.
1109 is that.
Criminal trespass, which was erstwhile 452, when you trespass into a house to commit an offense, that is made out.
Three-
This is 333 BNSS.
The new section 333 BNS.
Clearly made out, Lord, even by we're looking at the FIRs.
that is house trespass after
One zero.
Or you can, Lordship, will leave it to the new IO. I have no difficulty with that.
I think let them investigate.
Lordship may say any other offences which the new IO may catch.
The
118 कर दिया.
Transport investigating agency.
1182, my lord, that is already there in the 117, 1182, and 333 we will tell the IO.
Independently, fairly, and dispassionately.
Very deep.
And if it is found during the course of investigation that any other prima facie offence is made out, suitable insertion in the FIR shall be made.
Very deeply obliged.
Deeply obliged, Mr. Great.
Appropriate offences will be added in the FIR as well. Appropriate offences will be added in the FIR.
Very deeply obliged.
May please. My lord, in this matter,
I'm
even
so
if they
sorry.
succeed in the underlying
I'm so
arbitration,
sorry,
I
I
am
have
a
a request to
partner
make.
to the extent.
The arbitration award is already reserved.
It is reserved.
What is pending now? This is interim proceeding.
This is the
Once the
interim-
award is out, what will survive in this?
I'll tell your ladyship the difficulty. Even if they succeed, they're only to the extent of 20%. The land sale is being held up and there's a 3-year timeline as far as construction is concerned. That's an MIDC timeline. All I'm proposing is, if my offer is seen to be inadequate, they can bring an offer, my lord. And if the sale goes through, I'm willing to deposit as far as the court is concerned. My lord,
In a nutshell, it is this. I have put in 54 crores to start, sorry, I bought for 54 crores. To 500 crores I put in blood in this property. This man has invested 20,000 rupees. We have bought a property lot from MIDC. I have to develop the property within a particular time and build 10 lakh square foot. The issue in arbitration is whether he has a claim. If he has a claim, it's 20%. So, my lord, the property is worth 2,500 crores today. I can sell at 2,500. He can get a better offer in a week if he wants. I will keep below 20% in escrow with the arbitration. That is one. Two, otherwise I will mortgage the land below which has been prohibited to develop the property. It can't be that a person who has put in 20,000 rupees below in the kitty will hold up a project of 2,500.
That argument probably it merits consideration.
My lord.
But in view of the fact that now award can be announced anytime.
that's right. It's imminent.
My lord,
The mandate is till September.
my lord, at the maximum, even if he succeeds, his claim is 20%. According to me, his
That's
claim
not
is
our claim. Our claim
according
is
to me,
joint
he has been a partner.
In any case, once the award is passed, this order will automatically disappear.
That's right.
And then whatever is there in the award, then party will challenge
My
that.
lord, God knows how long it will take, my lord. 2 months have already gone. My lord,
September
we are
is
sitting
mandate
on a
is
property we need to develop, my lord.
Only 2 months have gone by. It will come.
I understand.
An award.
But my lord, at best, if his claim is 20%, I say it is 0. And
20% of what?
20% is the partnership.
Of what?
This is the main.
When the sale price comes, that 20% can be quantified.
That's
Your
right.
non-disclosure
Correct.
creates a smoke screen
Ross is right.
on the transaction itself.
I am the one who identified the property. I am the founder partner, the designated partner.
20%.
I am the one who identifies the property. He comes in later.
Cannot have any control over this.
My lord, he can get a better offer of more than 2,500.
As long as you are together,
That
you will get a best.
initially you agreed that he had 20%.
Right.
Later on, you have changed your stance that he has
Because
no
he-
rights,
right.
trust has been created.
So take it at 20.
Why you have
After the
created
arbitration.
that stance is because when he is a partner, he has equal right on the decision
Decision making.
process,
Provided you-
irrespective of the share.
Provided you put
And
in
you are-
money.
and when it is 20%, he
Yes.
cannot overrule you. But he has a right to accounts.
Right?
For right to accounts, he must know the exact coordinates and manner and nature of
I'm
transaction.
making a suggestion, my lord.
If
Let
there's-
him get a buyer of more than 2,500 crores.
And
in
the
this
award
court
is
and sell
impending.
it.
Award is impending. It will determine
It's
this.
not buyer, sir. It's a question of
What is the claim in arbitration?
accounts on dissolution of firm.
And also Lordship will
Lord,
see
he
his
hasn't
conduct.
sued-
Lordship will see his conduct.
Purpose is known.
Lord, just look.
8 SLPs is filed to stall the arbitral process.
What is
8
how you
SLPs.
start-
8 SLPs.
It is reserved.
The award comes, everything will. come
Everything
to-
will get resolved.
But Lord, with
That
great
is the
respect.
done in English.
They
Then
have,
there'll be an appeal
they
put
have
against
challenged
the
the
award.
extension of
Against
the
him.
mandate of the arbitrator.
Lord, he's not
Look
going
at
to
his
it.
conduct.
If you don't mind, can I come?
I do mind.
I
They have
want to
challenged
complete
the
this.
extension. They have challenged the extension
Because
of the
the point
mandate
is,
also.
even after the award, what will happen? There'll be a 34, there'll be a 37. This issue will arise. How long should we wait, Lord, for developing the? I am making a clear offer. At best, he's 20%, below, as the Lordship said. At best, I am willing to sell the property at 2,500 crores, right, and retain 20%. If we can get a better offer in the Supreme Court, you please sell.
Produce the contract.
I'll produce.
It's
Lord, I didn't. I had.
Redacted despite orders of the despite orders of the tribunal.
Lord, I
Despite
only-
orders and High Court says you
Oh,
are
the
in
buyer's
contempt.
name, I'll disclose to your Lordship.
High
Because
Court
these
says
are
you're in
not
contempt.
small amount.
It need not be disclosed to him or anyone.
Correct.
But you must
I'll
disclose
disclose to
it
you.
to the arbitrator.
Lord,
And when
High Court says you're in
arbitrator
contempt.
He has reserved, Lord.
rights.
He's not
High
listening.
Court
now.
says
He
you're
has
in
reserved.
contempt by not following that direction.
Yes.
That's a
Lord,
finding,
this
and
is
on
a
his
dog in the
conduct,
manger
look, 8
policy.
SLPs
I
he
will
has
not
filed
allow you.
to stall the
I
process.
will not do anything. Property should remain.
I
It's
am
an
the
FIDC property.
Found by
Yes.
the High Court, and anyway, the award is reserved. According to me, I think.
These things should stop somewhere.
I can disclose to your Lordship.
Have already been concluded and the award is likely to be announced at any time. We do not deem it necessary to interfere with the interlocutory directions issued by the learned arbitrator.
Very grateful.
Lord, contentions are left open, your Lordship.
They are
All the contentions.
they are always open.
Grateful.
He's online.
Yes, Lord.
In fact, not in this case, if I may say. My lord may permit me to appear through VC, Lord, I'm a little under the weather. But the issue in this case is that there is an SLP, there is a previous order, Lord, which has already been passed, which your lordship may just take note of, Lord, which is on record, where in the earlier round notice was issued. The High Court has gone on the point. Not kindly see P15 at 240 for a moment. There is an earlier SLP, not where your lordship has been pleased. 240, not 240. Lordships have been pleased to issue notice. Not the issue is really this. When a public official has a direct interest, a familial interest, can you be dealing with government projects like this? And we have placed on record, Lord, if I may just point out,
Party to the pending SLP will hear you. We don't want
yes,
to
but
add more and
might
more
not be
pieces.
tag this with the pending SLP, Lord.
No,
Might
no,
not be just
we will
tag.
We will otherwise permit you to assist us in the matter.
He's the same
Lord,
petitioner.
please tag this same issue, Lord. Please tag this with the pending SLP. P15 at 240, just tag it.
No, I mean, we have doubt on bona fides of this kind of.
Why not? I'll show your lordship. Lord, there was not, in fact, even the High Court didn't hold any doubt on bona fides. Please consider this for a moment. The only reason I've been hit is on delay and the fact that, Lord, and the High Court not, in fact, I must say this, in the earlier there was an issue regarding not some procedural defects. Matter had come up in SLP, and the High Court had dismissed on the ground that look, there's no challenge, and that's a factually wrong thing. Kindly just see two things, not just see. Look at P11 for a moment. P11 at page 93, and I want your lordship to see para 3.29. That's in the earlier round. 3.29 at page 102 bottom.
We can't understand that what prompted you to come to the High Court is in 2023.
Not
We had given series of complaints, Manoj.
series of complaints, not we move series, told the police keep
Complaint is that
footballing
you
us.
can't file at your will and fancies that as and when you want to
No,
file.
Manoj, 2018 the complaints were given.
18,
Police
not just see
doesn't
those
register
complaints.
those FIRs, Manoj. Series of complaints, Manoj. And the police says that it is not my jurisdiction, you should go to another jurisdiction. The other jurisdiction says, so I am only being sent from one place to the other and there is no complaint register, Manoj. Clearly, Manoj, contrary to what Lalita Kumari says.
22.
Malad, just see
writ is
page
then filed.
87.
Your RT application was 22.
Yes, Manoj. My writ is filed in 2022. My first complaint is of 2018.
Project was conceptualized when?
Yes, Manoj.
The
But project was
2002,
conceptualized not in the
2003.
90s. 2003, Lord, 2003. 2003, Lord, and I've been agitating this claim.
It is more than apparent that just to fight a political battle, all this so-called PIL is converted into.
My lord, the idea was to get an inquiry matters alive before your lordships. All we are requesting is let this be tagged. We'll assist the court in that when the matter
Page
comes up.
240, Miloj, to page 240 is the same petitioner who has filed the PIL, Miloj. The High Court in the impugned order records that PIL 3 is filed by me, Miloj. And there are irregularities that the High Court notes in PIL 3, Miloj. Would Miloj just see annexure P11, Miloj? The findings in P11, very serious.
Doubt of the bona fides of someone, we should not allow them to enter the court.
My lord, just see
bona fides-
P11. Mr. Joshi, one moment. My lord, just see P11 for a moment. I'll satisfy your lordship. See P11 for a moment.
No, sorry, we are not inclined to enter.
My lord, just see P11 for a moment. P11, just
2003
see.
project, 2009 project.
My lord, would your lordship, would your lordship,
Complaints and then come to the High Court in 2023.
my lord, may I just point out, just see in P11, Lord, just see two things in P11. If your lordship still feels, then we won't press beyond a point, Lord. Just see P11. Does the lordship have P11? Now see P11, Lord. Look at para 3.9 at Lord 102 bottom. These are the investors. Kindly see, family member comes in at 103. Then kindly just come to Lord 105. Para 3.38, man gives an interview, and please see 3.38C, recorded by the High Court. His daughter, the respondent number 13, and husband held shares. Now, Lord, 7.6, para 76, plot at page number 144. And then para 88 and 89, not at 158.
Yes.
We are mindful that petitioner knocked the doors of this court twice before the filing. We are also conscious to espouse the core of nature as raised in the present petition involving some powerful respondents, neither sui nor common. So the High Court notes my issue but says you're delayed, doesn't realize and says the earlier petition was dismissed on technical ground, but the SLP was pending. Now, not today, all I'm saying is this is an issue regarding not there is a problem regarding shortage of water to Pune. B, it's a question of damage to nature. They didn't have the permissions in place. And therefore, we went at multiple times for this matter to be inquired into. Surely not a matter of this nature which deals with the environment may be considered.
Thank you, Mr. Joshi. Thank you.
One last.
Would your lordship consider tagging it, not allow me to?
Look, Lalita Kumari has clearly laid down that for a cognizable offense, my lords are saying that I am a busybody. My lords, forget me, my lords, I am only putting the clock in motion, my lords. I am only saying that let the police look into it. And if it's a cognizable offense, my lords, they are bound to register the FIR, my lords. That's all, my lords. And my 2018 complaint raises very serious issues, my lords. The police is only scuttling the procedures and not registering the FIR, my lords.
No case to entertain. The High Court will write down. The High Court, having doubted bona fides of the petitioner, rightly refused to entertain the petition. Now we want us to comment something on the conduct.
No, Lord, would your lordship then permit me to intervene, not and assist in the pending matter at 240?
So pending matter, we will see. Somebody came on time, we entertained that.
My lord,
petition
my
is
lord,
pending.
all I'm saying is I'll
Coming
assist
back.
in that case, not, I'll assist in that case. I'm not asking for more than that.
No, no, we will not attach it. We will not entertain it. We have serious doubt on the bona fide part.
My lord,
Thank you very much. Thank you, Mr. Luthra.
Obliged.
Item 13.
Kindly tag with my lord the similar issue with regard to the policy.
How many matters you will continue to file? Tags with the UGC
Earlier,
matter. Tag with lead case. Arbitration civil number 101 of 2026.
Obliged.
Next. Expeditious disposal. While we are not inclined to issue, we are satisfied that no expedition in the Article 32 of the Constitution is maintainable for the reliefs as sought in this expedition. The Petitioner, whom I so advise, may approach the High Court with an application for expeditious disposal of the pending petition.
We have been filing the MAs there, but nothing.
Thank you. Next.
I have to set my house in order. There's a lot of confusion because one petition was filed.
Jalsebazi, narebazi, everybody does it in democracy.
Kya kare, sir? Mistakenly, one SLP was filed. Thereafter, we filed two other things. My lords may keep it next week. I'll set my house in order. But the office, my registry is creating some issues, I'm told. So registry may be directed to place all the three matters together. The objections are only very highly technical. What has happened is we challenged 3 orders in one SLP, which should not have been done in the first instance. Then we filed 2 other SLPs, then we moved an IAM side.
There is a beautiful poem written by Ashok Chakradhar on democracy. We will not recite it, though I remember the poem. I will not recite it because we have given report. But that poem answers all these questions.
It is sort of a comedy of errors, Manodi. But kindly have a look at the. But kindly have a look at the last order, my lords, of 26th of May 26, 22nd of May 26, my lords. Granted time as some connected SLPs are required to be filed and some necessary parties are required. So we did not implicate all the parties. In one petition, we challenged 3 orders, which should not have been done. We're trying to rectify it, but the office is saying that what we're doing is, office is raising objection that since we have already prayed in this, how can you pray in a second matter? The office may be directed to take a
It's all like Mr.
slightly different view.
Now that he is holding some responsible position, we understand that he will understand responsibility also.
Yes. My lords may keep it next week. I will get the thing rectified. And the office may also be directed to treat all the 3 to be in the nature of a single petition. If they treat them separately, then you say you already challenged it there, you can't challenge it here. All these hyper-technical objections are being raised.
It's all right, I think now. It's a case either way you can be taken.
A mini trial has been conducted and the matter has been quashed. I'll address my lords on merits, but I have been just briefed only as far as these technicalities are concerned. Give me some time, I'll address on merits. I have a strong case on merits also. This is my.
No, if you want to argue on merits, we will hear you. Otherwise, we are not inclined to interfere, frankly.
My lords may keep it on a short date. I'll argue on merits.
So request post the matter for hearing on Sunday.
The other matter is kept on 20th. It may be kept on 20th. Grateful, Manoj.
Please. My lords, despite 2 writ petitions pending in the High Court, my lord, the groundwater contamination levels, my lord, they have drastically increased, my lord. And these both the petitions, my lord, which the High Court has mentioned, it's an impugned order, my lord, they both have outdated record, my lord. And even, my lord, after 2010 and 2019, my lords, after filing of these petitions, my lord, the situation did not remain the same or become better, my lords.
The PIL filed by the petitioner has been dismissed by the High Court, primarily on the ground that similar petition bearing CWP number 11509 of 2010 and CWP PIL number 262 of 2019,
Please, my lord.
raising similar issues are pending before the, are already pending consideration before the High Court. So however, both the petitions are stated to have been dismissed or withdrawn.
No, no, my lords, they are pending. One was dismissed, my lord. Subsequently, application was moved, my lord. It was restored, my lord. It was dismissed because of non-filing of process fee, my lord. So last year, my lord, November.
So then, in the pending PIL, you become party there.
But my lord, they are outdated as PILs, my lord.
File an affidavit there.
I'll do that, my lord. Lordship may grant me permission, my lord. I'll do that, my lord.
Don't say it is stated. You can say the High Court has dismissed the PIL on the ground that so and so pending or pending. So one of those petitions are stated to have been dismissed.
Both are pending, my lords. One was dismissed, my lord, then subsequently it was restored.
In case of the matter, nothing precludes the petitioner to seek his impleadment in the pending writ petition and bring the additional facts on record.
Grateful, lordships. I'm obliged.
Lordship, in this, the compliance of order dated 30th October was already complied with on 2nd of December 2023.
Then you, it is your sweet will as and when you want to come to the court.
No, Lordship, I sincerely apologize. Lordship, he is suffering from cancer and liver cirrhosis.
Now I recollect that how much you harassed the court by making false statement one after the other.
No, Lordship.
You appearing for the respondent?
Please, sir.
Have they paid?
No, not paid. Lordship, compromise is there.
No case to entertain the
Compromise
application of dismissed.
Much obliged. Lordship, may kindly permit me
No
to.
question of entertaining application.
Lordship,
It's a clear case of abuse of process of law.
Lordship.
You obtained an anticipatory order from us, making false statement which you never complied with.
So, Lordship, that has been complied with, but due to the her health.
Yes.